The Waqf Act governs Muslim charitable properties in India, supporting mosques and community initiatives. In 2025, the Waqf Amendment Act sparked intense debate and legal challenges. Critics fear it gives the government more control, raising concerns about autonomy and religious freedom. So, the heart of the controversy lies in the perceived shift in power dynamics. Critics argue that the amendment gives the government more control over Waqf properties, potentially undermining the autonomy of Waqf boards. These boards are responsible for managing and administering these properties. Section 2. Voices of Dissent. Concerns and criticisms. The Waqf Amendment Act has been met with widespread criticism from legal experts, Muslim organizations, and opposition parties. They argue that the amendment is not just a matter of administrative reform, but a direct challenge to the Muslim community's right to manage its religious affairs. One of the primary concerns revolves around the amendment's impact on the composition and powers of Waqf boards. Critics argue that the changes could lead to the appointment of government-appointed members, potentially diluting the influence of community representatives. This, they fear, could politicize the boards and make them susceptible to government interference. Another significant point of contention is the amendment's provisions related to the leasing and sale of Waqf properties. Critics argue that these provisions lack transparency and clear safeguards. They fear that they could pave the way for the misuse of these valuable assets, which are meant to benefit the community. The controversy surrounding the Waqf Amendment Act reached a critical juncture when petitions challenging its constitutional validity were filed in the Supreme Court. The petitioners, including prominent Muslim organizations and individuals, argued that the act infringed upon the fundamental rights guaranteed by the Constitution. In an interim order, the Supreme Court provided a temporary reprieve. The court directed that no fresh action should be taken under the amended provisions, particularly with regard to properties already declared as Waqf properties by courts. This interim order provided a much-needed pause, allowing the court to carefully examine the arguments presented by both sides. The government, however, has defended the amendment, arguing that it is intended to improve the management and administration of Waqf properties. They maintain that the changes are necessary to ensure transparency, accountability, and the efficient utilization of these assets for the benefit of the community. During the hearings, the courtroom witnessed intense exchanges between senior lawyers representing the petitioners and the Solicitor General, who argued on behalf of the government. Senior advocate Kapil Sibal, representing one of the petitioners, argued that the amendment was, quote, unconstitutional and aimed at taking control of Waqf properties. While hearing both the sides, CJI Sanjeev Khanna made a shocking remark. You cannot rewrite 100 years of history. This shows that Apex Court of India will take steps to ensure balance in the amended Waqf law. As the nation awaits the Supreme Court's verdict on the Waqf Amendment Act, the decision will shape Waqf management and religious freedom in India. The Muslim community watches closely, hoping for a judgment that protects their rights. The nation waits, hoping for justice, equality, and protection of fundamental rights. Stay tuned to Qanun Plus Live for the latest updates on this crucial case and other important legal developments shaping our nation. Don't forget to share your comments and views on the Supreme Court's intervention on Waqf controversy and subscribe to Qanun Plus Live.